Hi, good afternoon, everyone.
Good afternoon.
Welcome on this bright, gloomy afternoon, but better than what it was yesterday. Um, we have with us, as usual, David Korman, and we're going to talk about the legal descriptions, easements, and rights of ways on properties that we own, that we sell. Eager to hear what David has to share.
Well, thanks, Sabiha. It is spring, right? It's not like we're going back into winter. Feels like winter again all of a sudden the last 24 hours, um but it but I know it's spring because there's been more activity in the real estate market. So that's how we know it's spring, even though the weather sucks. There's been action, so I hope you guys are all out there getting some deals done because there seems to be an increase in activity out there. We're certainly feeling it at our end. So hopefully today's topic will help you a little bit. It's not, I apologize in advance because it's not the most exciting, sexy topic. It's a little dry to some extent, but it's important for you to understand some of the basic principles when you're putting your agreements per sale together and you're looking at different properties for your clients. So it's worth the exercise of going through it. So we're going to talk about legal descriptions, easements, rights of way. We're also going to talk a little about surveys and title insurance. So I'm going to get into it, and I'll skip through our introductory slides, other than I always pause to show you a beautiful picture. There it is of David and David, only to show you how good David Gorski looks in this picture. Please check us out. We just recorded our 126th episode yesterday. So that one will be coming out soon. Hope you guys are tuning in and listening. There's some good information for you there. So please check it out. And let's talk about types of legal descriptions. So there's different types of legal descriptions. There's what we refer to as lot and block descriptions, which is the simpler type of description and what you would commonly see in subdivisions, which is pretty simple. Where your lot one on the plan of subdivision registered as M dash some numbers by the municipalities. So it's pretty clear. Your lot one, your lot two, your lot three, whatever. Sometimes it's part of a lot, but those descriptions are generally simpler. The more difficult type of descriptions that we come across sometimes are called meets and bounds descriptions. And they're more common for what are non-subdivision properties, but even some of the historical subdivision properties ended up with some meets and bounds, but it's usually non-subdivisions that were created this way. And they are complicated descriptions because you're starting from a point somewhere that a surveyor has planted an iron bar or something in the ground. So you start from some point and they measure in a certain direction for a certain number of feet. So it might be going, northerly for, for 30 feet to a point, and that might be the frontage. And then it goes from there, westerly for 100 feet, and then makes a turn, and it goes on and on in different directions and different measurements and stuff. So we have to actually map those out to figure out exactly where those lots are. So those are much more complicated. When you come across legal descriptions that are like that, it's more complicated. But just so you know the differences, you don't have to be an expert on it. That's what lawyers do, and lawyers rely on conveyancers who have more experience than we do. And there's certain times when we're on difficult properties, we're consulting with a conveyancer and bringing a conveyancer to help us out to figure out what the actual legal descriptions are of properties, or the legal descriptions for rights of way or easements and things like that. And of course, some properties will have the lot and block type of description, and they'll have meets and bounds descriptions as well. So don't get intimidated by it. There is a way to figure out exactly what there is, and we just have to work through it. Now, in Ontario, under our system, every property now has been assigned what's called a property identification number. We refer to it as a PIN. So every property has a PIN. So they'll still have a legal description underlying it, but this is a way of indexing the properties. and we can describe it by the PIN. And the PIN is also a numerical description, usually 9 digits, identification number, and that'll identify a property. But we can't just put the PIN into an agreement of purchase and sale when we want to provide a legal description for the property, because it's not the proper legal description. It's just an assigned identification number. But if we know the PIN, we usually, in your agreements, you should put the PIN in as well, because it helps when we do our search of the title to know what the PIN is to make sure we have the right property. So we'd still have the PIN, and then underlying the PIN, there will still be a legal description of the property, which might be a meets and bounds description, or it might be a lot and block description, or a combination of the two. So when you see the PIN, don't think, oh yeah, there's a PIN assigned. I've got the PIN number. It's just a 9 number. That's the only thing I have to put in for my legal description, because no, it's not enough. It's not an actual legal description. We need more than that. But the PIN is very important and useful information to include in your legal description. Now, I wanted to spend a few minutes talking about easements, and there's, just so you know, that there are different types of easements in Ontario, and some of the differences are a little subtle, but it's good that you know that there are different kinds of easements that are created or that exist. There's gross easements, which is a right over use of your property that's held by a specific individual. So it's a legal permission that's attached to the deed of a property that allows a specific individual to go over and use part of your property, or it might be the whole of the property. Depends how the easement is described. And there's a different type of easement that's called a pertinent easement, which is a right over the use of the property for the benefit of an adjoining landowner, no matter who owns it. So the right goes to the benefit of whoever owns the adjoining lands. So that's distinct from the gross easement, where it's a right granted to a specific individual to go across it. So an pertinent easement is the more common type of easement, because usually it's whoever owns the adjoining land has the right to cross my property. They have an easement over my property, and that runs with the land. So it's a legal permission that's attached right to the deed. Now, it should be on both deeds. So it should be on the deed. If I'm the person that owns the property and I'm giving someone else the benefit, the adjoining land, or the benefit to go across my property, it should be registered on my property that the adjoining landowner has an easement over my property, and it should be also on the adjoining landowner's registered legal description that they have a right to cross my property, and I'm their adjoining landowner. So it should be properly registered on both. Okay. Now, easements are created in different ways. The first way is an express grant of an easement, where an owner grants the privilege to use the property to another person and usually it's for a specific purpose. The most common type of express grant is a right of way, and easements and right of way are sort of interchangeable terms. And you see both of them. So, because a right of way is a form of easement, there's just different form of easement, but a right of way is a form of easement. It allows another person to travel across your property, usually if it's for a specific purpose. There are public and private rights of way. Okay, but if someone is granted a right of way, whether it's a public authority or it's a private right of way, it doesn't give them an ownership right over your property, but it does give them a right to go across your property for a specific purpose. So an example of a public right of way would be a road or a path through your land in order to access a public area. A private right of way would be an express grant that allows a neighbor to cut through your property to make their access easier. Okay, now we're not typically seeing those type of rights of way too often in urban settings. A lot of it is more in the residential settings, but it does come across in even urban settings as well, because some of you might be familiar with things like mutual driveways and things like that. And there might be a grant where you're allowed to go across your neighbor's portion of the driveway in order to get through to your portion of your property or your backyard or things like that. So you will see it in urban settings, and you will see rights of way like this in rural settings for sure. So a few examples of these is a deed granting one person the right to use another person's road. And that if it's granted that way, that'll be together with the right over a right of way over the existing road to access and egress the property. So that's the way it would be described. Okay. So so that would be together with a right. And any subsequent deed to the road will say that it is subject to the right over the existing road. Okay, so here an owner is granting the access rights to somebody else to pass over their road. And you see this a lot in cottage properties because sometimes it's the only way to get to their property. I recently did a cottage property on a small lake up in the Bracebridge area. And there's a road, a public road that accesses it. And off that road was really a driveway. It looks like a road, but it's really a driveway to one cottage property. And feeding off that driveway, there were road or access roads that lead off to 6 or 8 other cottage properties that are all on the same peninsula. So all of those cottage owners, the only way they could get to their property was to have a right of way over that one cottage owner's road because all of their driveways fed off that road. So that's an example of the type of situations that we're looking at when we're searching title. So on that one owner that has the initial connection to the municipal road, their title to the property will have to say that it'll be subject to the right of these other 8 cottages and define those adjoining landowners, not the owners themselves, but their properties, subject to their right to go across that portion of that owner's driveway so they can access their property. So on title to that owner, it'll say his property will be subject to the rights of the adjoining landowners. And then on each of the adjoining landowners' properties, the proper legal description that they have should say that they own their property together with a right of way to cross that one property in order to access their property. Unfortunately, when we were looking at title to this, there was no such description for this right of way. So the parties have been accessing the right of way by use for decades, but it was never registered properly. So they really had no legal access to their property unless we went to the process of getting that corrected on title to all of the properties, which is quite a process. So it's a very important thing that we look at these things. And we see a lot of these things, especially in cottage properties, waterfront properties, properties on lakes or rivers. Sometimes the properties are landlocked. You can't access them except by water unless someone is granted access across their property to drive over for the purpose of it. And when these descriptions are done properly, it should say in the description that not only they have a right over the property, but usually it's explaining for a specific purpose, like in this one, to access, for road access and egress, to come and to go across the property. It's usually defined for a specific purpose, as opposed to you have a right of way on my property for you to put up a tent and go live there if you want, because that's not what's intended. It's intended you can go across it so you can get to your property. And that should be part of the description that we find in those deeds. Now, there's another type of easement, and it's an easement by prescription. And this is granted through an adverse possession process, or what's sometimes commonly referred to as squatter's rights. So if an owner had their property and at some point in time they build a fence, for example, on their neighbor's yard, and it actually encroaches into the neighbor's property. Let's say it goes a yard or 3 feet into the neighbor's property because that's where the fence was built. And it was left uncontested for an extended period of time. And usually it's at least a 15-year period, well, 10 to 15-year period that it has to be left. And during that time, it was uncontested. No one complained. The fence was there. So the only party that had access to that strip of land was the owner who didn't really own that strip of land, but he was using it to the exclusion of the owner that actually owned that land. That owner can claim that it's now his. He's got squatter's rights on it. He's claiming that strip of land by adverse possession because he's exclusively used that land for a period of time sufficient enough to allow him to make that claim. Okay, so this is an encroachment that created an easement. So really the neighbor was encroaching on his neighbor's land, but because he put up a fence and the actual owner had no access to that strip of land for a long enough period of time, that owner might lose the ownership of that land, and that becomes an easement. So for that, so it's not something that happens very often because the facts have to fit the situation, but it is something that happens. This is like an easement by prescription. There's another type of easement by implication. In this example, there's two adjacent property owners. It's usually like row houses, buildings that share a party wall, and there's an easement to that party wall just by necessity because they share a wall. Sometimes they have to enter into a party wall agreement because they're sharing it. So if any repairs have to be done or things like that, there's an easement by implication because there's no other way around it. They're sharing a wall. So it's another form of easement that we sometimes have to deal with. And there's another form, and the fourth one I want to bring to your attention is an easement by statute. And this is usually for public services, creating easements so they can get access to facilities and equipment. You'll see it's mainly with utility companies that need easements for putting up wires or for drainage or sewers, things like that. So this is an easement by statute. Sometimes it's called an easement in gross, and it's usually like a public utility type of easement. So anyway, I think you got enough information that just so you know, there are various types of easements and they're created in different ways. Now, an easement is a grant of use of part of the property. It does not create an ownership interest. If someone has the benefit of an easement, they can use that property for that specific purpose, but they're not an owner of it. It doesn't transfer the interest of that land to them. The original owner still owns the underlying land. They're still responsible for the property taxes on the easement. They're still responsible for the maintenance of the easement. Nothing changes about that. Now, because an owner is responsible for the tax and the maintenance, an owner, if they're granting an easement to a neighbor, they can certainly negotiate for some cost sharing arrangement for that and enter into an easement agreement that might specifically provide that that property taxes or a percentage of the property taxes or a percentage of the maintenance or all the maintenance, whatever they can negotiate, might be shared. And sometimes it's shared by more than one party. In that cottage example that I was giving you earlier, where there's about 8 different cottages that need access across someone's driveway, they all entered into a cost sharing agreement because it has to be maintained, it has to be plowed in the winter. So they entered into a cost sharing agreement, and that's something that happens a lot of times when there's easements, especially when they're shared by more than one party. But the ultimate responsibility for that land still belongs to the original owner. They have to make sure the property taxes are paid. They have to make sure that it gets maintained. Whether or not they can negotiate to get contributions to that is another story, but it's their ultimate responsibility. Now, let me move on to the next one. The Land Registry Office keeps track of easements and rights of way. And that's why we take a look at the legal descriptions and how they're described on title. It's really important. So, and sometimes they're described by way of meets and bounds descriptions. Any easements created today, the registry office no longer will want to accept a meets and bounds description for that. If you're going to create an easement today, you have to get a surveyor to create a reference plan and create the easement by way of a description as part or more parts on a reference plan. And then the reference plan will get registered. And that's a much clearer, easier way to see exactly where the easement or right of way is on the property, because it'll show up very easily on a reference plan instead of having to go through this meets and bounds exercise, which drives everybody crazy. So I mentioned before, we've got to make sure when these easements or rights of way are created, they get registered on both properties, the property that's granting the right and the property that has the benefit of the right. So they're described oftentimes as the dominant property and the servient property, but we need the registration to be on both, so we make sure that it's there. And that's why when we're searching title, we're searching adjacent properties, adjoining properties, to see how things are described there. So on one property, again, it'll be described as the property is subject to an easement. And on the other property, it'll be described as the property is together with an easement. You're together with the right, or you're subject to the right. And that's the way it should be described. And that's what we're looking for when we're searching title. So there's a little bit of a difference between a license, a lease, and an easement. So a license grants an interest in all or a portion of the land for a specific period of time. A lease is a type of license, but it grants an exclusive use for a stipulated length of time. So it's a little bit different, just distinguishing. The lease is talking about the use of the property. A license is granting an interest in all or part of the land, so it's more focused on where it is. And there's a slight difference, just so you know, that an easement is a little different from a license or a lease, because the interest exists until it is terminated. Okay, so licenses and leases are granted for a specific period of time. An easement is granted until it's terminated. Okay, because usually it's open-ended and it's not terminated, because you want it to run for the benefit of whoever owns the land from time to time, because it's the only way the parties have access to it. So it's not usually something that runs out on time. So there has to be a termination down the road for it to be expunged. Now, in your standard form of agreement of purchase and sale, there's some protection built right into the printed form to protect buyers from undisclosed easements. If you look at clause 10 in your agreement, if a lawyer discovers an easement on or before the date that we're allowed to examine title, the buyer has an opportunity to object, because they found something on title, we weren't aware of it. Maybe we want that easement to you get rid of that easement or a right of way. So there is an opportunity to object to it, as long as we raise it within our requisition period. Now, if the clause 10 goes on to say that you can't raise objections if it's for minor easements for public service and utilities. So if we found an easement in favor of Bell, for example, to run cables on the property, or in favor of Hydro to run wires to the property, you can't object to that. And no buyer would normally want to object to that, because they want those services provided to them. So it's not something you typically object to. But other easements that we discover in our title search, we can make a requisition if it might be a valid requisition for the seller to get rid of that easement. So we could object to it. So you should just be aware of that. Now, is there an effect of easements on the value of a property? So yes and no. Certain easements, you can argue, actually will add value to the property. So just because the property is subject to an easement or together with it doesn't mean it's something that should be devalued. It could be adding value, because that's how access is obtained, for example. So it actually might add value and not take away from value. So you have to take a look at exactly what the easement is created for, the purpose of the easement, the type of use. So you'd have to look at each case on its own to determine whether or not it really is a material issue, and it might be affecting the value of the property, and it could be affecting it positively, or it could be affecting it negatively, depending on which side of the easement you're on and what the benefits and the rights are. So don't dismiss an easement right away. Say, oh, it's subject to an easement. Now, certain properties, it could be an issue. Like, it's easy to come up with a scenario where it might be a negative issue, because let's say you own a property and you've got the back 10 feet of your property is subject to easements for just for you basic utility purposes, or there's a sewer buried there or something like that. That might affect the value of your property to some buyer if their plan was to build a pool in the backyard and they can't use that back 10 feet because they can't build over this easement. So it's easy to come up with certain scenarios where there might be uh, a decrease in value because there are certain restrictions on a property, or what you can do with the property because easements are there. So you'd have to look, and it might decrease it for one buyer, and it might not affect the value to another buyer because another buyer comes along and says, well, I'll never put a pool in. I wasn't planning on doing any significant landscaping back there anyways. Doesn't matter to me. It's not going to affect my use and enjoyment of the property. I like it the way it is. So you'd have to look at it on a case-by-case basis. All right, so part two, giving you an outline. Hopefully I haven't put you all to sleep talking about exciting easements and rights of way. So stay tuned, wake up if you're having a little nap for part two. We're going to talk a little about surveys and title insurance and the significance and benefits of those. So a survey is prepared by an Ontario land surveyor. Okay, we want to make sure that a survey is prepared by a licensed Ontario land surveyor. And it's basically that surveyor's opinion on the extent of title with measurements that they're going to produce for the boundaries of the property. So they're looking with their abilities to measure on the ground, and they're looking at documents that are registered on title and the adjacent properties and information in there. And they're preparing a survey that's going to disclose the boundaries of the property, but it's also going to disclose locations of structures on the property and any other visible improvements. It should show fences, hedges, pools, overhead wires, and any easements or rights of way that are there that are affecting the property. And they'll have different descriptions for them, and it should all be showing on a survey. So first thing, it's always good, I'll tell you this up front, it's always good to have the benefit of a survey. And I'll explain title insurance in a minute and tell you how we can close transactions and that we don't really need a survey, but it's always better to have a survey than not have a survey. There's certain benefits that are disclosed by having a survey, even if it's an old survey. Okay, but we want to make sure we've got a survey that's been properly signed and certified by a surveyor, legible survey. Sometimes there's a bunch of old surveys out there. We'll look at them to the extent that they'll give us some information, but there's a big difference between a survey and an up-to-date survey. And up-to-date survey means something that's current today, that's showing the condition of the property today and whatever visible improvements are on there today, including things like fences and hedges and things like that. So you got to take a look at what you're actually getting. So it's always beneficial to have the most up-to-date information available to us. So we're looking at a survey to help us make sure we got the right property, we got the right shape and dimension of the land, and we're getting what's intended to be purchased or intended to be sold. So, but it also gives us a lot of other information as to the state of title, because we look for things like rights of way and the property boundaries. It gives us information on setback, municipal compliance with setbacks, because those of you that aren't familiar, even in a basic brand new subdivision, there are zoning bylaws that say that the house can only be built so many feet from the front yard boundary, and that there must be a certain amount of side yard setback between the boundary and the side of the house. So it helps us look at compliance with those things as well. There's a lot of things that a survey gives us information to. In addition to just telling us the basic boundaries of the property, whether anybody's parts of any neighboring properties are encroaching onto their property, whether there's an encroachment by way of a fence, it could be an encroachment by a hedge, it could be encroachment by a deck or a shed in the back of a property, a garage, the eaves troughs could be overhanging, things like that. All these type of things will be disclosed by a survey. So If we don't have a survey, we're not going to know about those issues. And if we don't have an up-to-date survey, we're not going to know if those issues still exist as of today. So we're going to be, there's a lot of benefits. Now, we can close without a survey. And on residential transactions, for those of you that are familiar with closing transactions through our office, you'll know that we will not close a residential transaction without title insurance. And if we have title insurance, we can close without a survey. Okay. But it's really, we can close without, we can legally close without title insurance, but it just doesn't make sense. It's not protecting the buyer clients enough. So it always makes sense to have title insurance as opposed to not have title insurance. But just because you have title insurance doesn't mean that you shouldn't also try and get a survey if one is available, and even better to get an up-to-date survey if that's available. And there's a list here of potential pitfalls when you don't have a survey. You could be, if you're looking to build, you could be building on a wrong lot or putting an addition on part of a wrong lot. We've seen examples of this. We might not be aware of a right of way that might be existing. There might be driveway issues or mutual driveway issues that we're not aware of. We've seen examples where people constructed properties on their neighbor's lot or built a garage or part of a shed on a neighbor's property. We've seen examples of cottages being built not on the property that they actually own, but on a road allowance that's owned by the government. We've seen cottages that are built over rights of way and then have to be torn down because it infringes another property's access. When you get a survey, it'll usually disclose where the septic beds are. And you don't want to be building on top of a septic bed on a property. We've seen swimming pools built in the wrong places or partially in the wrong places. There's all kinds of boundary disputes that would be disclosed by a survey if you don't have it, and could create issues like adverse possession, where someone can actually lose the benefit of a strip of their land if a claim could be made that they're no longer entitled to that strip of land, even though they're the registered owner of that land, because they haven't used it for a sufficient period of time, and it's been used exclusively by the neighbor who's exclusively used it and maintained it to the exclusion of the actual owner of it. So those things get disclosed by surveys as well. And certainly when you're on cottage property, any waterfront properties, shorelines are a moving target. And there's always erosion in shorelines. Water levels change all the time. It's really important to try and see exactly where the properties start and where the shorelines are and things like that. Retaining walls sag and start encroaching onto properties and move the boundaries and properties. So there's many pitfalls that are potential if there's no survey and no up-to-date survey available to us. So anytime there is one, even if it's an old survey, it's better than not having one. If we can get an up-to-date one, that's always good. Now, there's many properties we close and we really don't need a survey. And sometimes it depends on the buyer's intended use. If the buyer is intending to do some major landscaping or put in a pool or a tennis court or a sports court or something like that, it would always be beneficial to get that survey or any information, because they're going to need a survey done if they're going to do those type of improvements down the road. So I'm going to give you a couple survey clauses here, just so you see some examples of the clause. And you've got these in your precedents, I'm sure, something similar. And I'll remind you, never be a slave to precedents. Always read them. But this first survey clause means the seller is going to provide their survey. And it's described here as a survey that's completed and certified by an Ontario land surveyor. Make sure it's got that type of language. We want to make sure that it is certified so we know that it's a proper survey. And this clause goes on to say that it will show the current location. Current location, that's an important word here. The current location of all building structures, additions, fences, improvements, etc. Okay? Because if it's not showing the current location, it might have been a proper survey done 10 years ago, but it might not be showing the current location. Maybe it is still showing the current location because there's been nothing changed. But if it's a 10-year-old survey, we may want the seller to also provide a declaration to confirm that there's been no changes to the property since the making of that survey 10 years ago. Okay, so the language that are in these clauses are important. Okay, the second clause here is talking about them just providing an existing survey. They're not saying there's no requirement for it to be a current survey, but this is what is. We're giving you the existing survey, the one that we have. But here again, the language here is saying that it is going to show the current location of structures, building fences, etc., on the property. And this is where we added in a sentence that the seller will also give us a declaration on closing confirming there's been no additions or structures to the structures, building fences, or improvements since the date of that survey. So it just gives us better information, okay, because the survey might be old. So it might be more accepted as old, but we know at least we've got a sworn document from the seller saying that they haven't done anything to the property and everything's in the same position. So that's better. Okay. Now, when we're getting title to a property, it means that someone is getting legal ownership to the property. So the buyer is negotiating an agreement purchase sale that you're working hard to get to obtain good and marketable title, which means you're getting ownership free of the rights or interests of other people. So they're getting good and marketable title. That's what they're really buying. That's what the law states that they're getting. Okay. And we existed for decades and decades in this province when we provided a lawyer's opinion after we searched title and closed a transaction. We would provide an opinion in our reporting letter to the buyer client that you obtained good and marketable title to the property, free and clear of rights and interests of other people. It would language to that effect, good and marketable title. That all changed when title insurance was introduced to the province of Ontario. And that goes back into the 90s. I can't remember specifically when it was, but I remember being at a meeting in my office downtown. We had a partners meeting because we had someone coming in from First Canadian Title Insurance, who was the first title insurer to come to the province of Ontario. And we had their rep coming in to give us a presentation about title insurance, telling us this is going to, coming into the province, now been approved. It's going to change how we practice, change how we do things. So we should all get on board. And I remember after this presentation, he left and we had we had about 10 partners in there. We're all discussing and we're all saying, no chance. Like this is going to come and go like the hula hoop. It's never going to change how we do things. It's not going to stick. We're doing title, we've been searching title for years. We close certain ways. We don't need title insurance in our system. Well, needless to say, we were all wrong, a bunch of dumb lawyers, and title insurance came in and it's here to stay. And it has changed the way we close transactions. It changes the way we do our due diligence prior to closing transactions. So title insurance insures the buyer, the owner, against losses caused by existing defects in the title or ownership of the property. So what the title insurance system does, it basically says, instead of you doing certain searches, instead of you, for example, sending $100 to the city of Toronto to request a tax certificate to see what taxes are, or instead of you sending $100 to the building department to see if there's any outstanding work orders or zoning infractions, don't bother doing that. Instead, you'll buy a title insurance policy, and we will ensure that there are no such issues, or if there are issues that would have been disclosed had you done those searches, we will protect the owner against that. So for property tax, for example, they're saying just you can rely on whatever the seller tells you. This is how much the taxes are for the year. This is how much I paid for the year. Go close your deal, adjust based on that. If it turns out after the fact that was wrong, we'll step in and we'll protect the buyer and make sure they're whole, and we'll go chase the seller for you. if there's any adjustments. You can go ahead and close without finding out if there's any work orders against the property. If after closing you find out that there was a work order, we'll step in, we'll get it cleaned up, and we'll protect the buyer for that. You can go and close your transaction without an up-to-date survey. If you find out after closing that there was an encroachment on the property, there was somebody's garage was encroaching on your property or the fence was encroaching, we'll step in, we'll fix it, we'll pay for it, and we'll protect the buyer and pay for that. So don't spend money or time making certain inquiries. We'll give you an insurance policy instead. Okay. So now when we're using title insurance, as lawyers, we're not giving an opinion anymore that they have good and marketable title, because we're not doing all of those due diligence searches anymore. So we're now giving an opinion that the owner is getting good and insurable title to the property, because we've helped them arrange for a title insurance policy that will protect them going forward. So the protection is for defects that had we done these searches, we would have found them. But because we didn't do these searches, we didn't know about it. We closed. We found out about the issue after closing. The issues existed prior to closing, but we didn't find out about them until after closing. So now the title insurance company will pay to fix it up. So that's basically, in a nutshell, how the system works. Okay, they'll compensate the owner for those losses that occurred because of existing defects that we didn't know about, because we didn't make those inquiries prior to closing. We only found out about them after closing. Okay, so policies are issued for residential transactions. I've told you we won't close in our office any transactions residential without title insurance. There's too many benefits to having the policy as opposed to doing it old school way. Commercial transactions, though, we look at it on a case-by-case basis. The search requirements, the due diligence requirements are different from the title insurance point of view for commercial properties and residential properties. Sometimes we decide we're doing enough due diligence on commercial properties that we really don't have an additional benefit to the title insurance policy, because we're doing all the searches anyways. Now, one benefit of title insurance that you get, whether it's commercial or residential going forward, is fraud protection. So even if we closed a commercial property, by doing all the due diligence searches, didn't have title insurance, and somehow after closing, even if we have a corporate owner and someone impersonates the corporate owner by saying I'm the signing authority and then arranges for financing and creates a fraud, there wouldn't be fraud protection because we didn't have title insurance. So there's still a benefit to title insurance, even if you're doing all the due diligence searches. So even on commercial transactions, more and more these days, we are getting title insurance, even though we're doing a whole bunch of searches and due diligence inquiries. So there are benefits. So anyway, just so you know that. Now, here's some examples of potential defects that could be covered. There could be liens on properties, could be condominium liens if it's a condominium transaction for unpaid common expenses. We see those different types of liens on different types of properties. So there's potential defects for that. There's encroachment issues that I mentioned before. There could be disputes with your neighbor about fences and hedges and retaining walls that are sagging and leaning in the wrong places. Sometimes there's just errors made by surveyors, and there could be access issues because of that. We could have building and zoning compliance issues. There may have been a permit issued for some construction on a property, but maybe they didn't get a final inspection and they left the permits open, or they didn't complete the job and a work order has been put on it by a previous owner. So those are examples of we wouldn't know about that because we're not making the inquiry. So if it turns out we're not looking to see if there's any outstanding open permits or deficiency notices, and we close the transaction, we don't know anything about it. We find out after closing that there is an open permit or there is a work order or deficiency notice. We weren't aware of it. That's the type of thing that we just send that to the title insurance company on behalf of the owner and say, hey, we just became aware of this. here's the title insurance policy number. Please look after this. And they do. And they cover all the costs of looking after that, fixing it, keeping the owner whole, including court applications if necessary, lawsuits against other parties if necessary. That's what their role is. And it's insurance, like any other insurance. It's a numbers game. They know, wouldn't know what the number is, but every 1,000 policies they issue, they're going to have one problem or two problems or whatever their numbers are. It's a numbers game. And they know they're on certain files, they're going to have to pay out large sums to fix issues. But overall, obviously it works in their favor. They collect enough on their on what they're charging for these policies that it offsets the eventual payoffs that they know they're going to have to make in certain circumstances. So I did mention one of the big advantages of title insurance is fraud protection. Okay, and fraud is always around. The fraudsters are always trying to stay one step ahead of the good guys. But that's a benefit. You get title insurance, you close a transaction today, you buy a title insurance policy as an owner, and your ownership is protected. One-time policy payment is protected for as long as you own the property. Okay, it doesn't matter if it's 1 year, 20 years, longer. As long as you own it, you've got one policy. You're not paying a premium annually. You pay one time. You've got protection. So you've got certain coverages that help us close the transaction. But in addition to that, you've got coverage going forward if some fraudster comes along and tries to steal your identity and sell your property out from under you or refinance your property. And if those things happen, it gets thrown to the title insurance company. They'll protect the owner under their policy and they'll go chase the bad guys. And if they can collect, great. If they can't, that's too bad for the insurance company, but the owner will get protected. So that's critical. And that's one of the main reasons that we insist on title insurance when we close transactions, especially on residential. Now, obviously, there are certain exclusions from coverage. If there was a known defect to the buyer before we close, if we know there's a problem before we close, then the buyer's not going to be protected through title insurance for that. We can't keep that away from the title insurance company, then try and close and then say, oh, title insurance, I closed and I got this problem on it. Because if they find out that we knew about it, the buyer knew about it in advance, they're not going to cover it. Okay. There's also no coverage for environmental hazards. Not a big issue on residential transactions for the most part, but occasionally there could have been an oil tank, an old oil tank on a residential property that may have leaked or something like that. The title insurance will not cover the remediation of something like that. And they certainly will not cover any defects that are created by the new owner. So if the new owner does something, if the new owner buys a property and then builds their deck in violation of the zoning bylaw or something like that, or puts their shed in the wrong place, and then it comes back and it's found out at some point in time and there's a work order or deficiency notice, they can't turn to their insurance company and say, hey, fix this, because no, the answer is no, you did that, you created it, so we're not giving you coverage for that. But if it was created by a prior owner before you bought the property, you certainly have coverage for that. Now, the cost of title insurance, as I mentioned before, it's a one-time premium. The title insurance companies, we use 3 different ones. They're all very, very competitive in their pricing on residential. There's very competitive commercial as well, though we do see a little more fluctuation on commercial transactions. They all base their premiums based on the value of the property. So it's all a sliding scale based on the value of the property. So we can always get a quote from them. When we get quotes from more than one, you'll see it's very competitive. It's all based on the value of the property. As the properties go up in value, the more the premium. But the key thing to know, if for those you don't, it's a one-time payment. Okay, you close today, you pay a premium, you don't pay annually, you don't pay again, and you've got the coverage going forward. So, question is probably going through your mind, well, do I still need a survey if I have title insurance? Okay, and I already alluded to that a little bit before, and I can make an argument that it's we're going to close with title insurance. Still a good idea to have a survey if one's available. Okay, so it's definitely a misconception to say that you don't need a survey. We can certainly close without a survey. We close most transactions either without a survey or without an up-to-date survey. And I'm talking about residential transactions. Okay. So title insurance specifically permits you to close. They don't need a survey. They don't need to see an old survey you have it. It protects you from not having a survey. And if you don't have a survey, you don't have an up-to-date survey, you close your transaction. And if it turns out you find a defect after closing that would have been disclosed had you had a survey or an up-to-date survey, you'll get protection and coverage by title insurance. That's the whole purpose of this system. Okay, so the system works. The buyer will get what the buyer physically sees at the time of closing. And if it turns out there's a defect that disclosed afterwards, that's the route they're going to go. They're not looking back to the seller to say, hey, you didn't let me know there was an encroachment on this property, by the fence, and I got a problem with the neighbor and I got to move it. The recourse isn't going to be back to the seller. It's going to be to the title insurance company, which has deeper pockets than the seller usually would have in any event. So now there are certain things that title insurance does not do. Title insurance will not show you how far the house is from a lot line. It will not show you where to install your fences. It will not cover the ability to install a swimming pool or a garage or a hot tub or those type of improvements. It will not fully protect an owner from damages for any misplaced border fences or party walls or retaining walls. Okay. Now, you will get some partial protection for that, because if we didn't know about it at the time of closing and we closed afterwards, and maybe the neighbor is selling their property, their neighbor's gonna do something, and they see that there's an encroachment or there's a problem with a retaining wall or something. So we can then, as the owner, rely on our title insurance to say, oh, title insurance, you go fix this with my owner that just discovered that I'm encroaching onto their property and they want to move something. So you go fix that instead of me. Okay. So an argument can be made, it's that they're both, title insurance and surveys are an important part of a real estate transaction. They do different things. One's really not a replacement for the other. So what's really important for you as a realtor to know, you have to understand what your buyer wants to do with their property. Okay. If they're intending to buy the property as is, where is, not do any improvements physically outside, not adding a shed, a garage, doing landscaping, putting a pool and things like that, they're just going to live with it. You don't have to worry so much about trying to get a survey as well. You have to understand the buyer's intentions. Okay. But if you do have knowledge, or you are aware that they plan to put a pool in, for example, it's really beneficial to get a survey before they get too far into the transaction, because maybe there is a 10-foot easement across the back of the property for a utility company and they can't put a pool in because of that easement. So that's certainly going to affect what their intended use of the property is. And even though you got them all excited and found this perfect property for them, turns out it's not a perfect property for them, because you should have known your client's intentions, and they always wanted to find a property they could put a pool in the backyard, and they can't on this particular property. It might be a great property for somebody else that never wants to put a pool in, but it's not good for this client. That's not a good situation for you. So know your client. Okay. Never a bad idea to see if there is a survey. It gives us a lot of useful information. Okay. So with that, I'm going to throw it back to Sabiha. I'm sure there might be some questions. And if anybody doesn't want to put questions in the chat or come on and ask a question, please reach out to me privately at any time. Best way to get a hold of me is through an email, and we can set up a time to talk. So please don't hesitate to reach out.
David, I have one question.
Yeah.
Sometimes people say we have a survey, but we can't find it. Is any replacement survey we can get from the city hall for like?
Yeah, that's a good question. The city doesn't keep track of surveys, but on title, like there's registered documents certain plans are registered on title, like there's that are prepared by surveyors. So there could be a plan of subdivision that'll give certain information, usually with the lot lines. Usually doesn't show the buildings on it. So there's certain information we can get through the registry office. If you can't find the survey, but you might know which surveyor, maybe they know which surveyor it was that made it. The surveyors are all really good about keeping historical records. So you might be able to go back to that surveyor and say, please look in your records and see what you can find for 123 Main Street and see if you have a survey on file. Okay. That's another useful way to get a survey updated. Sometimes you're given an old survey on a transaction and it's 10 years old or 20 years old or something, and you want to get it updated. Instead of going to a surveyor and starting from scratch, a lot of times it's better to go back to the surveyor that created that first one, because they usually keep all their records and information, and they can you ask them to just update from that point, and you'll get it faster, and you'll spend a lot less money on it to get an up-to-date survey done from that.
And I want to add one more thing to there. If like your subdivision was built like in 1980 and your neighbor and you bought the house same time, and your neighbor has a copy of survey and which shows your lot line, is good enough for you?
Oftentimes it is. That's a great point. You'll see that a lot in some of the new subdivisions, when they do surveys, and this is when the house is being built, they'll create surveys that'll show more than one lot. It might be 2, it might be 3, it could be 5 or 6 sometimes, and it all might be on one survey. So you look at that, but usually in those type of surveys, usually they're done after the foundation is poured, and there's usually a designation right on. You'll see, the boundary of the lot lines, but then you'll see the outline of the house on it as well. But there'll usually be designation on it. It might say something like DUC. And that will be, there's a legend, you'll take a look at it, and what it'll mean is that's dwelling under construction. So that means they made the survey after the foundation was poured. So the outline that you're seeing there is an outline not of the built house, but it's an outline of the foundation that was poured. Now, sometimes the house then gets built, and we've seen the house gets built, and then eaves troughs are added and the roof line is added. And sometimes you would see there's an encroachment of a roof or a lot line that might be encroaching onto a neighbor's property, but you wouldn't see that because there's no encroachment on the foundation level, but there's only encroachment up at top at the roof line. So you just have to be careful what you're looking at and how you're looking at it. But that's a great way sometimes to get a survey of a property. You can't find one here. Check with the neighbors, because they might have a survey that shows your property on it. And if it shows your full property on it, as opposed to just a partial, just shows the common lot line and just part of it, if it shows your full property, then that's a valid survey prepared by Ontario Land Surveyor.
Thank you.
Any other questions, guys? All right. Thank you so
Sabiha,
much,
I have a
David.
question if it's
Yeah,
not too
sure,
late.
Nader. Go ahead. Yeah, absolutely. Go ahead.
The question for David is, once when we are writing an offer, how do we differentiate between a easement that is use of a land by neighbors or just a utility easement?
That's a good question. We really have to look at how it's described on title. First of all, we want to see if it says subject to or together with. And the short form that you'll see actually in a legal description, if it's subject to, it's usually S/T, subject to. If it's together with, sometimes it just says T/W, meaning together with. So we're looking at that. But sometimes we actually have to take a look at the actual instrument that created the easement to see exactly how it's described. And I just had this happen a couple days ago. I was contacted by an agent who was putting in an offer, wanted to put in an offer. Multi-offers were expected. And he said, this property backs onto a ravine. And it looks like the use of their backyard looks like it's beyond, it looks like it goes 10, 15 feet beyond what they think the lot lines are for everybody, because it's sort of extending into the ravine a little bit more than all the neighbors' lot lines. So he said, can you take a look at title just to see if there's anything there, anything registered like that? And he said, because it looks like in the description, it says that it's that there is some sort of easement or right of way back there. So we take a look at title, and it turns out that what was registered on title was just an easement in favor of Bell that ran across everybody's backyard just because they had cables back there. So it didn't really give an answer to that question. And so but it looks like because we don't have an up-to-date survey. Okay, we don't have the benefit of an updated survey here, but it just looks like to the naked eye that their lot line's in one place, but they're using about 15 feet beyond their lot line, which is really part of the ravine beyond them. And the ravine is owned by the city. The other side of the ravine is parkland. This house has been up there 75 years. It's never going to be redeveloped. It's always going to remain a ravine. And the city could at some point come in and say, hey, you're not supposed to be using this 15 feet here because that's really not your backyard. But in the meantime, it's been used for, probably 75 years as part of their backyard. Okay. So there's no ownership rights there, but the buyer actually ended up being the successful buyer. I got the deal in yesterday, and they just decided to take a chance with this. They didn't want to get an up-to-date survey because they don't want to know for sure that this backyard, this extra piece, goes beyond their lot line. They want to just use it until somebody stops them from using it. So they don't want an up-to-date survey. They don't want to know if it really belongs to them or if they have a right to go on it, because previous owners have been using it for so many years. They want it too. And chances are they'll be able to use it and no one will ever say anything because it's not really interfering with anybody. Until the city of Toronto decides to get desperate and decides to sell all their parkland to developers. And if that happens, then yeah, someone's going to come along and put a fence in the proper place, and they're going to lose that extra 15 feet.
David Tarr is asking, as a listing agent, should we volunteer a copy of the survey we have on hand or not?
That's a good question. I would wait to be asked. Not that you generally have anything to be afraid of, and if they're asked, you give it. Like, I don't think there's a real downside in giving it, but I would wait to be asked. But if there's any question about them wanting to see it or anything, then why not have it? And if you do have one, I prefer you actually attach the survey as a schedule to the agreement of purchase and sale. Like, if you already have it, attach as a copy of the existing survey. That's it. That's all we know. We're not giving you anything else, as opposed to leaving it, well, we're going to give you a survey 3 days from now, and then get into a battle of, well, was this an existing survey? Was this an up-to-date survey? Is this a current survey? I can't really read it. It's out of date. It's not legible. Much simpler. Just attach the survey, and this is it. All we have is what's attached here to a Schedule D. Just attach it. And Tara, I'm sure, I know you deal in cottage properties, and you're dealing with all kinds of issues that could come up with surveys. But if you're dealing with properties up there, any buyer should be looking for any survey information that's available. Old survey, new survey, updated, whatever the information is available. Let's see what it is, because it really helps us understand the property.
David, I have a question. It's Jeff. How are you?
Okay, Jeff, how you doing?
Good. Just regarding title and with probate, should we be having let's say some of the inheritance members, should they be going on title before probate starts, or do you wait after and do the probate process? I know that's a loaded question, but
yeah, I'm not sure I understand the question, but so we have an owner that owns a property, they die. You want to sell the property?
Right. Yes.
Okay. So you can't sell the property without somebody having the legal authority to sign the documents for the sale of the property. That's usually the estate trustee, okay? Who is the executor. State trustee, executor is the same thing. So you have to go through that probate process, because that's the process that appoints the person to give them the legal authority to sign the documents to close the sale of that transaction. So you couldn't close until you finished that and got that appointment of the estate trustee. Okay. While you're applying for that, the party that's applying could sign a listing agreement, could sign an agreement of purchase and sale to sell the property, but it has to be conditional on closing only when they get the certificate of appointment. So I hope that answers your question, but it's really another topic. You can reach out to me anytime, Jeff, and I
Yeah,
can talk to you
sure.
further about it.
Let's do that, because there's some
Okay.
other parts of
Okay.
it. Yeah, thank you, David.
Okay.
All right. Thank you, everyone. Have a great, wonderful rest of the week. Thank you, David.
Okay. Thanks, Sabiha. Take care, everybody.